Okay, you're up, Mr. Conigliaro.
May it please the court. My name is Matt Conigliaro. I'm with Carlton Fields, and I'm here today on behalf of the appellant in this case, Mr. Jugal Taneja. I'd like to save 3 minutes if I could for rebuttal. We have appealed the trial court's entry in this case of a nearly $10 million deficiency and trial court attorney's fees award. The trial court entered those awards based on a guarantee that Mr. Taneja executed, but on which he was not sued. The trial court did so on 2 grounds. First, that count 1 of the complaint included a claim against Mr. Taneja on the guarantee. And second, that this court's prior appellate attorney's fees orders were law of the case and required not only that trial court attorney's fees be awarded, but that a deficiency judgment be awarded. On appeal, FSFA has added a 3rd argument into the mix. They have argued that post-judgment, that a trial court has the power to enter deficiency judgments essentially on any basis. All 3 of those positions are incorrect, and I hope to discuss all 3 with the court. First, with respect to DSP's complaint, which was never amended, it did not sue Mr. Taneja on the guarantee. Count 2 of that complaint was an action on the guarantee, but it was only against 2 other guarantors, not Mr. Taneja. Count 1 included Mr. Taneja as a defendant, but it was purely an action to foreclose a mortgage. And Mr. Taneja was named simply because he held a subordinate interest on the property at issue that needed to be extinguished in order for a foreclosure sale to proceed. The trial court said, well, the guarantee was attached to the complaint. That's true, but it was attached to the complaint and expressly incorporated into count 2. It was not incorporated into count 1. The trial court also said, well, the relief in count 1 asks for fees and costs against the defendants, but the trial court misread the prayer for relief. The actual language asked the defendants to be the defendants responsible, and I'm quoting now, for sums due under the note and mortgage to pay them. Taneja was not a party to the note or the mortgage that were—
Leaving aside your other arguments, focusing just on that argument, just the simple fact that he was not a party to the note and mortgage. If I know this is the ad damnum clause, but it says if the sums due, if they're seeking sums due under the note and mortgage from all the defendants in isolation, does it matter that Mr. Taneja has not a note and mortgage if that count had included him and had alleged that he was a guarantor? Why would it matter whether he was actually a party to the note and mortgage?
Well, it matters in the sense that it clarifies what was being requested. There was no allegation in count 1 that Mr. Taneja was a—
Well, let me rephrase what plaintiffs would a borrower will a lender will often say, I want sums due under the note and mortgage from you, and you. You borrowed the money and you guaranteed it, right? So in isolation, in that scenario, the guarantor could not say, oh, I wasn't a party to the note and mortgage, so therefore sums due under the note and mortgage can't be recovered from me.
I understand that, Your Honor. I believe
The guarantors have separate rights under their guarantee contract, correct? I mean, they can say, oh, I was entitled to a certain notice that I didn't get.
Absolutely.
I mean, the guarantee is a separate contract, correct?
Yes, it is, Your Honor, separately enforceable. And as the court has noted, there are times when these claims are brought together. But reading the complaint—
unless the terms of the guarantee say otherwise, they can go directly against the guarantor in a lot of cases without ever suing under the note or the mortgage.
Well, what happened in this case is that both really happened at the same time. But what's important to recognize is that count 2 was a claim on that exact guarantee,
on the same guarantee,
but not
correct,
against Mr. Taneja or Dr. Soraya. Now, stepping back from the sort of the plain language of what we see in the complaint, all of this actually makes perfect sense when we appreciate the larger circumstances. Taneja and Soraya got together after Fuel defaulted on the $4.8 million loan. They formed DSP for purposes of buying the $4.8 million note and the accompanying mortgage from Broadway Bank. They did that. That's why this complaint was filed by DSP. And when they did that, they sued to foreclose the mortgage with respect to Fuel. And then they chose 2 other guarantors, not themselves, to sue in count 2. All of that makes complete sense. Why would they, to do that, to acquire the mortgage, they paid $1 million out of their own pockets and took out another $3.8 million loan. That comes into play.
In a way, they've already paid up.
Well, they've taken on another obligation.
I get it. I get it.
If they
Yeah.
haven't paid enough, the other guarantors would have right of contribution against them, presumably, right?
In theory, there could be claims in all sorts of directions, but the way it was handled was done intentionally so that as a result, they had control. Broadway Bank didn't decide who to bring into this suit and who to sue under the guarantee. DSP had purchased these things and DSP was in control. And so with that context, all of this makes complete sense as to why it was handled the way it was handled. And in fact, that's exactly what FSFA admitted to the trial court back in 2014. And now I'm quoting, this was FSFA's counsel. They said, Mr. Tanasia is not being sued on his guarantee in this case. Mr. Tanasia was listed as a defendant solely because he has an inferior lien. There is no claim against him for money on his guarantee. That was FSFA to the trial court in Pinellas in this case in 2014. And of course, it was 5 years after this complaint was filed and now 6 years ago. So, and obviously FSFA had a bit of a, well, but as things unfolded, they changed, right? Mr. Tanasia and Dr. Soraya had a falling out. FSFA went on to purchase the note and mortgage from DSP. FSFA also went on to purchase the $3.8 million note and mortgage from MB Financial, which succeeded to Broadway on that separate loan. And all of those claims at some point then became sort of in the hands of FSFA. And it was in that connection that the second amended answer was filed in 2015 that the other side relies on so much to say, oh, we knew there was a claim against us for money damages because our second amended answer said that we want to invoke rights of contribution and set off.
Could you address that real quickly? Because there seemed to be, that, you know, I think your argument was, yeah, because there was either the 3.8 or the 4.8 that we had a right of contribution on, but not. Could you clear that up? What was actually what was actually still at issue? Because I think opposing party is saying that your argument is that the right of contribution was as to your liability in the 3.8, but your liability in the 3.8 had already been released. Am I correct or incorrect?
I believe Your Honor is correct to a point, but with respect to the release, there wasn't.
Not a release, but it had been eliminated.
Well, no. Years later, FSFA would take the position that that's now been released, but that wasn't what was happening at the time. At the time, there were pleadings that sued Mr. Tanasia by MB Financial on the $3.8 million note. And so when FSFA had purchased the $3.8 million note and the mortgage. And so those claims existed. The second amended complaint was filed after the trial court formally substituted FSFA for MB Financial. And so at that point in time, if you're Mr. Tanasia, you're looking at a set of claims all in the hands of FSFA that came from different places. One set came from DSP in the original complaint, but another set came from came from MB Financial, and that separate claim that was still filed in this litigation. So the defenses that were pled were simply broad. They said things like, if FSFA is entitled to damages, then we're entitled to contribution and set off. That didn't change. There was no claim under the guarantee in the original complaint. That complaint was never amended. The litigation didn't change from that point. The guarantee was never litigated, never adjudicated. The final judgment of foreclosure and the final judgment on the counterclaim that proceeded up to this court in the earlier appeals did not impose any liability or make any finding against Mr. Tanasia, except with respect to his property interest, which was extinguished. And so for all of these reasons, there was no claim against Mr. Tanasia on the guarantee. And now we find ourselves post-judgment, and FSFA is trying to argue that, well, we're entitled to attorney's fees and we're entitled to a deficiency under the guarantee, but we're post-judgment. The trial court doesn't have authority, doesn't have jurisdiction even, but doesn't have authority at that point to basically try a new case, a new claim that was never pled in this case. And we've raised with the court the Zooland case from this court in 2018, where the appellant in that case, or an appellant in that case, argued that it shouldn't have been subject to guarantee proceedings at the deficiency judgment stage. But this court said in that case that you were sued, guarantors, you were sued on your guarantee in this case. And so, of course, the court had jurisdiction to then continue with that claim and ultimately enter a deficiency judgment. But the giant distinction between this case and Zooland is that in this case, there was no claim against Mr. Tanasia on the guarantee. The claim on the guarantee was solely against two other guarantors. The argument has been made in the answer brief that I do not believe was pressed below, is that, well, I think they're saying apart from whether it was pled, that they can raise this with the trial court post-judgment as a deficiency matter based on the statutes. And that's simply incorrect. Yes, there's case law talking about deficiency judgments and how these things proceed, and that's rather standard and a matter of course. But in the typical case, a claim is brought on the note and the mortgage.
And for the purpose of this argument, it does matter that Teneo was not a party to the note and mortgage, because under the run-of-the-mill foreclosure, you can get a deficiency judgment against the party to the note and mortgage.
Yes, and those two instruments lose their separate identities. They merge into the final judgment, and typically in the typical deficiency judgment setting, what's really happening is we're enforcing the judgment because that note and the mortgage have merged into that final judgment. So it's really just an enforcement proceeding. What happened here was completely different. This was not enforcing a note or the mortgage. This was trying to enforce a guarantee that was never the subject of the complaint. That's why it's so important to be able to go back to the original complaint, which was never amended, to say what were the claims in this case. And now the third argument that was raised relates to law of the case. The law of the case basically holds that any issue necessarily decided by the higher court controls in the litigation going forward. But it has to have been necessarily decided. The only item necessarily decided when this court in the prior appeals entered the attorney's fees awards was that the proceedings were within the broad fee shifting language of that guarantee. This court did not decide that a deficiency judgment was owed by Mr. Tanasia. This court did not decide that a guarantee claim had been pled in the trial court, or that an attorney's fees claim had been pled properly in the trial court. And so on all of those issues, law of the case just doesn't apply here. So I mean, ultimately, the two grounds that were raised by the trial court fail for legal reasons. And now this third argument that's been raised here in the appeal fails for legal reasons. And the deficiency judgment, it's a $9.4 million judgment on a guarantee that was never a claim in this litigation by DSP. The second point in our appeal is very similar. It relates to attorney's fees. There's a roughly $350,000 award for attorney's fees. That was never broken down by the other side into what was appellate fees and what was trial fees. But we objected to the trial fees as a whole because it was never pled for the same reasons. The complaint controls here under Stockman and a legion of cases. You must plead entitlement to attorney's fees in your complaint. And for all the reasons we've already discussed, that didn't happen here. There was an intention.
You have to sue on the contract that has the attorney's fee provision in it.
Yes, Your Honor. And that didn't happen here. So the attorney's fees award cannot stand. The trial court portion of the attorney's fees award cannot stand as well. And if I could save the balance of my time for rebuttal.
Got about 6 minutes. Okay.
Good afternoon. Excuse me. Good morning, Your Honors. May it please the court. Andrew Geekus on behalf of the Applee First Street and Fifth Avenue LLC, who I'll refer to today as FSFA, as we have done so in the papers before Your Honors. I wanted to first address a question that Judge Atkinson had asked Mr. Canigliaro regarding the affirmative defenses and the correlation between the $4.8 million note and the $3.8 million note. The operative second amended answer in affirmative defenses that we are referring to within our answer brief is the one that was filed on, I believe, September 23rd, 2016. By that time, in 2012, December of 2012, FSFA had purchased the $3.8 million note and $4.8 million note, not from DSPP, but from MB Financial, because at that time, DSPP had defaulted under its obligation to the bank, and the bank had essentially utilized its rights under the proxies and other collateral documents to take possession of the note and mortgage. And so at the time that FSFA acquired the notes, it sent a letter to counsel for Mr. Tenasia attaching the $3.8 million note, the separate note that MB Financial had filed its third-party claim on. It attached that to a letter and marked it as canceled, explaining to counsel for Mr. Tenasia that his obligations under that note, they were canceled and he was no longer liable under the separate $3.8 million note, but was still liable under the $4.8 million note. And so that's important because when we look at the second amended answer in affirmative defenses, Mr. Tenasia's affirmative defenses are separated out. He has separate, I believe there are 9 affirmative defenses that are raised in opposition to the foreclosure complaint itself. And affirmative defense number 4 and 6 are affirmative defenses for set off and or recoupment, and also one for contribution, where Mr. Tenasia is arguing that to the extent FSFA is awarded any damages as against Mr. Tenasia individually, or Mr. Tenasia is found liable under the foreclosure complaint, count 1, then he has a right for set off, recoupment, or contribution as against Dr. Soraya, because he is a co-guarantor, and then through FSFA.
So what does that get you? Let's assume that that the contribution defense was toward the toward the debt that they're saying he wasn't sued on. What does that get you? That just gets you an inference that could be drawn that either counsel for Mr. Tenasia was just covering the bases, or that an inference that might be drawn that he thought that he was being sued that he was liable in count 1. And so he might as well, make sure that you had belt and suspenders. What does that get you? What does that get you in terms of us concluding that this case should be affirmed?
Yes, Your Honor. So we believe that goes to one of Mr. Tenasia's primary arguments is this notice and opportunity to be heard, that he did not have notice that FSFA was going to seek to hold him liable under his guarantee pursuant to.
Okay, but does that get you all the way to the point where we conclude that the relief was properly pled for? In other words, yeah, okay, he had noticed that you wanted it, but if you didn't properly plead it, if you didn't properly plead that that you should receive damages under the guarantee, then what does that get you?
Yes, Your Honor. So it goes towards his notice that we were seeking it under count 1, but it also, which establishes the trial court's continuing jurisdiction to enter deficiency orders and judgments of this kind. And so we turn to the Florida Supreme Court case that we cited in our briefs of Coffrin v. Sales, of how a trial court can maintain jurisdiction to enter deficiencies order, and how a litigant invokes that court's jurisdiction. What the Supreme Court has told us in Coffrin in 1937 is that a deficiency judgment can be entered upon a motion or other appropriate pleading filed after the confirmation of sale, and that notice is given to the defendant and giving the defendant an opportunity to be heard. And the Supreme Court went further and held that the trial court's jurisdiction to enter the deficiency must be invoked either by express prayer in the complaint or by subsequent appropriate pleading or motion. So we filed an appropriate pleading before the trial court, seeking to hold Mr. Tenasia as well as Fuel liable for the deficiency after the confirmation of the sale of the property. We did this because Mr. Tenasia was already a defendant in the underlying original foreclosure action.
In count one?
Yes, Your Honor. He was a defendant in count one. And the law under Coffrin, as well as the law post Coffrin, as well as Florida Statute 702.06, it provides a litigant two avenues to seek a deficiency judgment, one being by filing a motion in the original foreclosure action, and the second is going out and filing a independent lawsuit as against the individuals or entities you're seeking to hold liable under the deficiency. The reason why, and through the case law, the reason why we see that this second avenue is sometimes required is in order to establish personal jurisdiction over those individuals who are not otherwise in the original foreclosure proceeding. Here, Mr. Nasia was a defendant in the original foreclosure proceeding. The court already had subject matter jurisdiction over the entire case. The court had personal jurisdiction over Mr. Nasia. The court had continuing jurisdiction to enter further orders such as the deficiency judgment. And so it made sense under the law to file the motion, the appropriate motion for deficiency, seeking a judgment from Mr. Nasia and other ones who we sought to hold liable. And that is what we did. We filed it back in August of 2017. Mr. Nasia responded. He opposed it, obviously, and that proceeded to a hearing in 2017 where the trial court deferred ruling until such time as this court had either affirmed or reversed the entry of the foreclosure judgment that Mr. Nasia had appealed at that time. This court ultimately affirmed the trial court on the foreclosure judgment, as well as its independent judgment on the counterclaims that Mr. Nasia had raised against FSFA. That was in early 2019. So then it was time to tee this back up before the trial court, the issue of the deficiency. Mr. Nasia filed a second supplemental response in opposition to the deficiency motion. And then so we proceeded to a hearing before the trial court, prior to which Mr. Nasia moved to continue the hearing. And his basis for wanting to continue was that he did not have enough adequate time to conduct necessary discovery in order to obtain fact witnesses, expert witnesses, or obtain documents in order to defend against the deficiency motion. That motion to continue was granted, and so.
Can I interrupt your train of thought? I hate it because you'll have to go back to it. Let's just say we took count one in isolation, and this was not a a rather complicated business partnership saga, and it was just a run-of-the-mill foreclosure. And there was a party was named who had a junior lien in this foreclosure lawsuit, and that party happened to also be a guarantor, but there was just the count one as it's currently pled, and there was a foreclosure judgment on, and then afterwards there was a motion for deficiency judgment. Could they come after this party who had been named as a junior lien holder just because that party happened to have a guarantee?
Well, yes, Your Honor. Yes, Your Honor. That's what we are arguing because.
Just take it in isolation. Let's say there was a one count complaint, count one. And you're named. You're a junior lien holder. There's a party to the note and mortgage. There's a property, that securing the debt, foreclosure judgment. Okay. And then, oh, hey, you know what? This guy happens to be a guarantor, so we get a deficiency judgment against him too. Is that the way it would work?
Well, Your Honor,
on a motion after the final judgment of foreclosure?
Yes, Your Honor. And the key point there is the motion, the appropriate motion in order to invoke the trial court's continuing jurisdiction to enter a deficiency judgment. If those parties were not before the trial court would not have had personal jurisdiction over them. And so we would have had to have filed an independent action. But since all the parties were already before the trial court, since the trial court continued to maintain its subject matter jurisdiction, since there was the relief in the wherefore clause asking the trial court to enter a deficiency judgment and any other relief that was appropriate. And because the trial court had reserved jurisdiction to enter further judgments and orders, such as a deficiency judgment, the trial court maintained its continuing jurisdiction. And so, as we see in from the first ECA's opinion in conference, the motion for deficiency judgment acts as a complaint initiating this subsequent proceeding, because a deficiency.
Isn't that only when they were originally sued on a guarantee or on a note? You can't just come in and ask for a deficiency for somebody who wasn't part of the original complaint, can you? Is that what you're arguing?
Well, he was part of the original complaint. He was.
Well, he was, but not on the guarantee. So are you arguing that he's not there as part of the guarantee? He was there as part of the original complaint on the note and mortgage, and now just through a simple motion, you flip a switch and now he's subject to $9+ million in damages?
Well, it's more than just a simple motion, Your Honor. The motion, he had every ability to respond and raise other defenses that he believed that he had. He had the opportunity for 2 years from the date that he opposed the motion initially till the time that the trial court eventually got to the full day evidentiary hearing to do the necessary
distinction
discovery.
between what I think Judge Starrs was talking about and what you're talking about now. There's notice. You've raised a lot of people raising both parties are raising the indicia of what the other side had notice of. Hey, you had noticed that you might be liable for a deficiency judgment because you sought contribution. But isn't there a separate issue, which is whether you properly pled in your complaint allegations that allow you to seek a deficiency judgment against the party, against Mr. Sneha? That's a separate issue, isn't it? Other than, I mean, I understand it's about notice, but it's also just about the fact that a trial court can't grant relief not pled. You can't, I mean, unless you conform the pleadings to the facts or something like that, you can't say, hey, well, you were on notice. You knew I was coming after you for deficiency.
You knew you signed this guarantee. I mean, it's like you got to have a claim brought against you. As I say, you could have defenses to the enforcement of it. If the claim's not brought, I don't know how being on notice that someone might at some point bring the claim can help you out.
Yes, Your Honor. Well, we're arguing that the motion itself under the Florida Supreme Court's decision in conference was the appropriate vehicle to raise the issue of.
Well, let me ask you that. So let's say, this is a peculiar scenario because the guarantor, well, maybe it's not peculiar. I'm sure it's happened before. The guarantor actually is a junior lien holder. So, hey, you happen to be here. We named you because count one says we also want all the defendant's interests to be foreclosed. So, hey, you're here. So, but you would not argue that in a scenario in which the guarantor happened to be a junior lien holder, so happened to be named, a scenario in which that a junior lien holder was the guarantor did not happen to be named, as that after a foreclosure judgment, this motion for deficiency can then be prevail against parties that were never a party, right? I mean, you would agree with that, right?
Yes, Your Honor, we would agree with that to the extent they were not otherwise defendants in the original foreclosure proceeding, then the only avenue to seek a deficiency would be to file an independent lawsuit in order to invoke the court's subject matter and personal jurisdiction over those defendants. But here, because they were defendants, we had two avenues. It was to go ahead and file the independent action, which
what if they had been on a separate count for slander of title or something? Just bear with me. and there'd been absolutely no allegation whatsoever that there was ever a guarantee signed. And you say, oh, well, you were a defendant in my slander of title count. And I also moved to foreclose. Perhaps this hypothetical is a little too far-fetched, but my point is, just by virtue of being there incidentally, can the motion substitute for what should have been a separate action against a guarantor?
I think we would have, yes, Your Honor, I think we would have to go further and look to see what that hypothetical wherefore clause requested, to the extent that it requested relief as against that defendant and requested that the court enter a deficiency judgment or grant any other further relief, that under that hypothetical, possibly it would be appropriate to then move for the deficiency in that action. The issue is Mr. Janasia and his moving papers, they haven't cited any authority in which a court in the state of Florida has held that what has done here was improper. They cite cases such as the Bayview case, in which they argue applies, but when we look at Bayview, in that instance, it didn't deal with the deficiency or anything post-judgment. There, the trial court did not enter a motion for, it was I believe a single count foreclosure complaint. The trial court denied foreclosure because there was an issue with the description in the property, and therefore it just entered a money judgment that was not otherwise requested. So the trial court there completely morphed what was being requested from a simple foreclosure to a pure money judgment. That is not what we have here. We have a post-judgment motion for deficiency, to which Mr. Janasia had fully been a party of in the underlying litigation, and he was the only defendant. From 2012 to now, he has been the only litigating defendant in the underlying action. He has asserted multiple counterclaims, third-party claims, cross-claims, and affirmative defenses, seeking contribution and set off to the extent he was held liable. So he was on notice and had this opportunity to be heard, fully raise any defenses that he cared to have raised. The issue that we find is that the guarantee document, he waived all his affirmative defenses under the guarantee other than payment. He further waived any right to a jury trial, which was one of the bases that he opposed the entry of the deficiency motion, because he claimed that he would have been able to have a jury trial on this issue, but he had waived his right to a jury trial. And his additional affirmative defenses that he possibly could have raised, he already had. He raised affirmative defenses of fraud, that FSFA somehow fraudulently induced Mr. Janasia into executing all of these loan documents back in 2006, when FSFA was not even a legal entity at that time. It wasn't formed until 2012. But regardless, the trial court, in entering its foreclosure judgment in 2017, entered it over all of Janasia's affirmative defenses. So he rejected and denied all of Mr. Janasia's affirmative defenses. So there was nothing left for Mr. Janasia to argue in defense of his liability under the guarantee for this deficiency other than payment. And we know it's undisputed that the debt has not been paid. And so, excuse me, Your Honor. I apologize. And so so Mr. Janasia continues to argue that FSFA, what it did was it was unable to proceed in the manner in which it did, and yet cites no authority for that proposition. Instead, again, in addition to the Bayview case, he cites this court's decision in Zooland, which all that it stood for was whether or not the trial court had the continuing jurisdiction. We are arguing that this trial court below did, in order to enter deficiency judgment against the guarantors there, where the litigant had not otherwise obtained a judgment on the guarantees. And this court said that the court, one, did have jurisdiction in the motion, did have jurisdiction to entertain the motion for deficiency judgment, and that the motion for deficiency judgment was not entered in error. Ultimately, the court reversed the trial court below because there was this issue of fact regarding whether or not the guarantors and the lender in that case had agreed that they were not going to be liable. Essentially, they had agreed to waive their defenses to the foreclosure, and in exchange, they would not be held liable under deficiency. We do not have that issue here. Mr. Janasia, I'm sorry, Your Honor.
You've pointed to Mr. Janasia's affirmative defenses of contribution as indicia that Mr. Janasia knew he was liable for deficiency judgment under the complaint as pled, and that essentially that means the complaint was properly pled. Now, on the flip side, Mr. Taneja has pointed to indicia that FSFA actually didn't sue him in an account that would give rise to a deficiency judgment against him, that he was merely named as a party, as a junior lien holder in order to foreclose his rights in order to foreclose. Now, how do you deal with those representations of counsel?
Yes, Your Honor. While I cannot speak for Mr. Lennon or why he made the statements at the time in which he did, what I can say is that although Mr. Lennon was not the attorney that filed the complaint on behalf of DSPP back in 2009, it was obvious to Taneja at that time, Mr. Taneja at that time, who was a member of DSPP, for the reason why the complaint was drafted in the manner that it was. Nothing about Mr. Lennon's statements to the trial court came as a surprise to Mr. Taneja, or arguably should not have come as a surprise to Mr. Taneja, since he essentially was part of the plaintiff at that time that filed the complaint. But
at this point, I need to stop you because you're gone. You and Judge Atkinson have gone beyond your time.
Thank you, Your Honors. That we would rest on our papers before Your Honors and request that the judgment be affirmed. Thank you.
Okay, thank you. Mr. Conigliaro?
Thank you, Your Honor. The discussion has prompted me to try to make a distinction or a clarification. I'm going to try not to get sort of confused in the terminology as I try to do it. FSFA is pointing to the second amended answer that we filed, as if to say somehow the affirmative defenses we pled there created a claim against us, against Mr. Taneja, under the guarantee. But the clarification I want to make, or at least the distinction I want to draw, is to highlight what was being said. What was being said was in response to claims that Mr. Taneja owed on a $3.8 million note that he signed. That was the MB Financial transaction that MB Financial succeeded from Broadway on. This basically the second transaction. That in response to claims that he owed on that note, Mr. Taneja raised that there was contribution and set-off defenses to be raised. Those are from his point of view as a defendant, those are defenses. Basically, I'll put it this way, it's using the guarantee affirmatively, not because Mr. Taneja was a party to it, but because Dr. Soraya was a party to it. And that's how it was being raised. It was being used defensively to say, I would be entitled because Dr. Soraya was a party to that guarantee. He wasn't saying, the fact he was a party to the guarantee had nothing at all to do with that defense, nothing. It had everything to do with the fact someone else was also a party to that guarantee, and that's what was being used. And as we've said, it was being used in connection with that $3.8 million claim, which had nothing to do with this guarantee. The $3.8 million claim involved that later transaction. The $4.8 million guarantee involves the original transaction. So hopefully I managed to not make a mess of that and clear that up, but it's a complicated situation.
Well, heaven forbid that there should be any mess in this case.
I appreciate that, Your Honor. If I could end with one final point, getting back to this overarching issue of notice. And if I heard counsel correctly, it was said that Mr. Taneja should not have been surprised when FSFA stood up in court and told the trial court that Mr. Taneja is not being sued on his guarantee. Well, of course he wasn't surprised. That was the way this was handled all along. For years. This case was filed in 2009. The judgment wasn't entered until 2017. The statements that we're talking about were in 2014, so 5 years later. Of course, he wasn't surprised. The other side wants to say that we were on notice that he would be liable under the guarantee. And I guess I would turn that and say, it's actually exactly backwards. That Mr. Tanasia wasn't on notice of anything. He had actual knowledge that he was not being held liable under the guarantee because it was his company, DSP, that filed the original complaint in this case. And it was his company that sued two guarantors, not him and not Dr. Soraya. It was his company that named him only for his subordinate interest in the property in count one. So he had actual knowledge that he was not being sued. When did all that change? In 2017, after there'd been a falling out and suddenly there was an effort to try to reconstruct reality or reimagine the pleadings. And now it's an action by motion post-judgment against Mr. Tanasia on a guarantee that was never the subject of the complaint in this case. And for all those reasons, the judgment here should be reversed. It should be reversed as to the deficiency judgment, and it should be reversed as to the trial court attorney's fees, which were also never pled. And if the court has any further questions, I'm happy to take them.
Okay, thank you, Mr. Conigliaro.
Thank you.
In order to leave, you folks should click the leave button, which is over in the lower right-hand corner of your Zoom screen, and then we'll call the next case.